because she didn't realize that when she turned in the keys that she was essentially surrendering.
What are we doing on this case?
Well,
Go ahead.
This isn't just a rent dispute. It's a case about misunderstanding, trauma, and how one decision can legally erase your right to a home. What you're about to hear shows how fast paperwork can outweigh human pain in a courtroom.
This is an unusual case in my experience, Your Honor. So Ms. Weatherspoon, we obtained two sources of rental assistance for her, and her balance was paid in full, but she still owed September rent, and she talked to the office about doing a payment plan and had terms of a payment plan that we thought we were all in agreement with. And today, while I was while Miss Inget and I were trying to get the terms of the COD in writing so that we could submit it to the court, I was told that Miss Weatherspoon had moved out and surrendered her keys on September 19th. So I talked to Miss Weatherspoon about this, and my understanding of what happened is Miss Weatherspoon's partner was murdered in July. The people that are being investigated for killing him some of them live in Hamilton Crossing, or associates of them live in Hamilton Crossing. They've been harassing her. She's felt very unsafe. She has young children. So she went to the office to ask to be moved, and she was presented with a VAWA form to fill out, which she submitted along with a police report about the harassment. And she agreed to surrender her keys on the 19th. Now, she didn't know that this meant she was giving up her rights to her housing. She thought this was a process that she had to comply with to be moved to a new place. And so she was she did turn in her keys and she did sign that paperwork, but she did not understand the repercussions of doing so. And unfortunately, I didn't find out about this until today. I think she viewed it as separate from the non-payment of rent case and thought that she had handled it properly herself. So as we sit here today, she did present a payment plan. She owes September rent. She had a acceptable payment plan to catch that up by mid-October, as well as pay October rent by the end of the month. But now she's possibly homeless with small children who are, still lost their father this summer, and it's just kind of tragedy and trauma on the family if that's the result of this process.
Mr. Fink.
She turned in a notice to vacate saying she'd be out on the 19th. She put her keys in the drop box. The landlord, with a notice to vacate and the keys, took possession of the unit. It was essentially vacant. I'm not saying it was empty, but from our perspective, possession has been surrendered. The landlord has taken possession, and reasonably took possession. It's not an unlawful ejection, and she did also turn in a form under the not under VAWA, but under the statute, asking to be removed, I think, under the state statute. But we have possession of the unit because she surrendered possession.
I don't know, Ms. Bauer, that I can order them to put her back in under these circumstances. I mean, it is kind of strange, but she voluntarily gave up the unit over in that direction.
Well, Your Honor, I don't know if you want to speak to her directly, but she thought that she was complying with the process that was necessary to have her rehoused. She did not understand that she was completely giving up. And I would say that my conversations with her did not align with her believing that she was giving up, because she was talking to me about how she was going to catch up her September rent this whole time. So and also it doesn't really meet the VAWA, the conditions of VAWA, but she was given this form by the office to fill out. So I think it was a very confusing situation for her and there should be some consideration for her confusion.
Well, yes, certainly. I mean, I would have, in looking at it, if she had, say, turned in the keys, but they had not yet taken possession, that might be one thing. Or, landlord had a judgment, they were issued a writ. That's one thing. I'm not sure that on a possession case, where I've not rendered judgment, but then the tenant has voluntarily surrendered, I don't know how I put her back in. If you're following what I'm saying. I mean, I get it if the landlord had done something during the course of that process, this process, that would lead her to leave or to surrender, but that's not what has transpired here, from what I understand. I mean, the only thing that's leading her to do that is rightfully or wrongfully, but it's not the landlord that's causing the angst.
Your
It's
Honor,
other people.
if I could just say one more thing, Your Honor, I don't think she would have turned in the keys on the 19th if she hadn't believed that that was what she needed to do to be rehoused. And I think that information did come from the landlord. And she's nodding her head
information?
yes.
Your
That
Honor,
there,
may I think there's no reason not to believe Ms. Bauer when she says her client made a mistake, but yet she surrendered possession. And by the way, Your Honor, I've got some photographs. I'm looking at an empty living room. She surrendered possession. She's vacated the unit. I'd like to submit an order of dismissal that includes the line that defendant surrendered possession. It may be there's some relief for her somewhere in reapplying for a unit or seeking some assistance in finding another unit, but she moved out. My client has possession. I think this case is moot.
Yeah.
Your Honor, if I could just say one more thing. Miss
Sure.
Weatherspoon was homeless when she moved into the unit, so she never had for a lot of furnishings, and she didn't remove the belongings that she had from the unit because she didn't realize that when she turned in the keys that she was essentially surrendering the unit.
Your Honor,
I don't know how that's.
I don't want to prove the case, but these pictures don't back that up. And I'm not saying anything about Ms. Bauer, and I think she is reporting what she believes to be true, but the photographs don't support that. And I also think it doesn't matter. She surrendered possession. We all agree.
I mean, I don't know that there's anything I can do. The issue of possession by her actions has become, and I think that's probably true, that it's now moot. I don't, in this case. I mean,
Okay.
she did the act.
I'll submit an order.
All right. So what I'm going to do is I'm going to dismiss this case. The issue is moot. The provision will read that defendant did surrender possession of the property.
Thank you, Your Honor.
All right.
Thank you for listening to us, Your Honor.
All right. Thank you.
The judge didn't question her story, only her actions. Turning in the keys meant surrendering possession, and once that line was crossed, the law had little room to bend. So tell me, should courts protect intent, or do actions always speak louder than words?